The University of Pennsylvania Law School is proud to welcome Radhika Coomaraswamy as our visiting international law faculty. As we celebrate the 25th anniversary of the Beijing Platform of Action and mark the 20th anniversary of Security Council Resolution 1325, we are honored to have a discussion with one of the global leaders who has spent her entire career creating normative and real change for women globally. I would not be exaggerating if I were to say that few have done more than Radhika Coomaraswamy to create normative change for women. And few have made women, children, and minority rights central to the Security Council agenda the way Radhika has done. In 1994, the United Nations Commission on Human Rights appointed Radhika Coomaraswamy as Special Rapporteur on Violence Against Women. She was the very first Special Rapporteur on this newly created position that was decided in 1993 at the Vienna World Conference on Human Rights. When Radhika was appointed as the first mandate holder, the world rejoiced. The women's movement globally rejoiced because she came through the global movement on women's human rights. As the first UN Special Rapporteur for Violence Against Women, Radhika created the seminal international framework on state accountability for violence against women. Just in order to map the change that she made and her work made, when she started her work in 1994, only 4 countries had violence against women legislation. And today, only 49 countries do not have such legislation. And very few law review articles on violence against women globally refrain from citing Radhika Coomaraswamy's work as the first UN Special Rapporteur on Violence Against Women. So the way in which both scholarship and the world of practice have used her frameworks is really remarkable. Her 1996 report on the Comfort Women, an authoritative account on how during World War II women and girls were forced into sexual slavery, set the stage for later ways in which we continue to address atrocity crimes against women and girls sold in sex slavery to whether it is the ISIS, the Boko Haram, and Al-Shabaab. So her work, her authoritative work on Comfort Women was standard setting. Upon the request of Secretary General Ban Ki-moon, Radhika also led the authoritative global study on UN Security Council Resolution 1325, which is considered the crowning achievement of the Women, Peace and Security agenda, and which disrupts traditional notions of securitization and militarization. Radhika called upon states to shine the spotlight on women as agents of peace rather than as victims of war. And transformative justice, Radhika emphasized, should accompany not only formal justice, but healing, reconciliation, and reparations. In other words, she called upon the United States as well as the United Nations to beat their swords into plowshares, which was really the original mission and vision of the United Nations. As Undersecretary General for Children in Armed Conflict, Radhika combated impunity at every level. Traveling to some of the world's major theaters of war, she addressed government as well as combatants, appealing for handover of thousands of children and child soldiers to child protection of actors. Currently, she is a member of the high-level UN fact-finding mission on Myanmar, addressing one of the biggest humanitarian crises of our time, involving 700,000 Rohingya stateless refugees. And in attacking the root causes of the crisis, Radhika has appealed to pluralist notions of democracy that value diversity and inclusion. So today we have with us Radhika, who is going to speak to us about what I think are the 3 major inflection points in her career as an international trendsetter, a global trendsetter, an agenda setter, and a thinker, a global thinker on issues concerning women and children. If we were to organize her work under three major pillars, starting with her work as the first UN Special Rapporteur on violence against women, the way in which she framed and created a new normative framework to understand and examine and combat violations of rights against women, we would start from 1994, when you were first appointed the UN Special Rapporteur on Violence Against Women. So can you talk about that particular moment in time, the importance of that mandate, and the ways in which you first and foremost elevated the mandate, you expanded the mandate, and the way in which you blazed a trail on international women's human rights in that sphere?
Well, thank you for that introduction. But I think what happened when the first Special Rapporteur took office is that we had to first fight the human rights establishment. For the human rights establishment was so used to the state being the end product of our agitation, free prisoners, free civil and political rights, that the thought that they would be the police and would be a partner in fighting violence was something many human rights activists did not like, male human rights. They said, actually, that's not a good idea. That's a criminal issue. It's not a human rights issue. So first was to push back and find a framework where they would accept how we would deal with the state in this. So we turned to the Velasquez judgment and says the state responsibility is that the state has a duty to prevent, prosecute, and punish all those who commit violence against women. So a due diligence duty is the framework that we brought forward as a framework that hooks in the state in this fight against domestic violence in a human rights way. And that doctrine took hold in the international level. And now whether at CEDAW or whether special rapporteurs look at countries, they do it through this due diligence. Do you do the due diligence? Do you have the judges, the prosecutors, the survivors' kits, and a checklist that we also devised with regard to that?
So I'm going to ask you to stop there and explain further the Velasquez-Rodriguez norm, which was about state responsibility even when the state was not directly responsible for the crime, but its inaction. But by its very inaction, the state could be held accountable for not taking proper steps to address a human rights violation. And that was the doctrine of the Velasquez-Rodriguez case, and you expanded that in the area of international women's human rights and held states responsible for inaction, for not having a law on violence against women, for not for law enforcement not responding to calls made by women who were under attack. So that has become now what I would say
default framework.
The default framework, but also the kind of what I would say the agenda setting. You set the agenda and the normative framework, and that we now continue to use. So can you speak of your missions, the missions that you undertook as the UN Special Rapporteur? You traveled to so many countries, meeting with government, heads of state, government officials, and survivors and victims of violence.
Yes. So how we organized, besides creating this doctrine of due diligence, we organized our visits around this notion of violence in the family, which would include especially domestic violence, violence in the community, which especially looked at things like trafficking and sexual harassment, rape, and also then violence in situations of armed conflict or custodial violence. Now, in the area of domestic violence, perhaps the most interesting visit was to Brazil, where because of the high rates of violence, they had created special police stations to deal with domestic violence cases. And because the act of honor crimes existed in Brazil, that is, if a man to some extent thinks you're having a relationship or has any proof that his wife is having a relationship with another man, he can kill her. So these kinds of crimes, other kinds of levels of violence, had made Brazil very aware of these issues. So we went there, and Brazil has now, of course, changed its laws. But that was one. But also I watched how these women's police stations, very, very seized with the issue, also dealt with the problem. I went with them on one of their calls and watched them actually deal with the situation. I also dealt with victims of domestic violence. And there, for the first time, I realized that what we write on paper when it comes to the victims, there is ambivalence. On the one hand, they want very much their husbands to be punished, or more like scolded, but they do not want them put behind bars because they lose their livelihoods or they are that, and how one deals with that ambivalence that they often portray when you talk to them is something I think has been the history of the women's movement since. We also looked at the issue of rape in South Africa, because very high levels of rape. Now, of course, we know what's going on now, but it was very high even in 1995, right? Immediately after apartheid was over. And also the way the different parts of South Africa dealt. In the white South African area, there were rape suites, and really they had the state-of-the-art material with regard to rape. Little packets that are given to rape victims. She would be seated in a pipe room full of music, lawyers, psychiatrists, psychologists, all were brought to her. And she was dealt with by a women's group that entailed all that. But on the other part of town, in Alexandria, a rape victim has none of this. She has to go herself to get her medical test. She has to be subject to all kinds of bureaucratic tests and scrutinies before she gets her status. Finally, I think we dealt a lot with the trafficking issue, which I can talk about later, but also women in custody. And I came to the United States with regard to that, looking at women in prisons. Because the Supreme Court had held that female guards were being discriminated against because by not being in men's prisons, they could not get promoted. And therefore, they made the ruling that men can serve in women's prisons and that women can serve in men's prisons. This led to a spike in sexual violence against prison mates. Female inmates, because there were now male guards in the prisons. And human rights took it up. A lot of the prisons movement in the United States took it up. So we came. I was not greeted with great warmth by the United States administration, but we visited those prisons. And it was interesting to me the kind of issues they were having. We recommended some kind of procedures that could be set up for those women to have grievance procedures. And I must say, of all the prisons I went to, strangely, it was the prisons in Georgia that actually were the most progressive. I found this very interesting. They had set up grievance procedure, and they had that was a very good man who was at the top, and a more rigorous facility. Maybe it was also a more manageable facility. But in Michigan and in California, Texas, it was barely looked up as an issue that was necessary. So that was on the issues of
So your work has been authoritative in the reporting under the CEDAW, which you referred to earlier, the Convention on the Elimination of Discrimination Against Women. And many CEDAW reports mentioned your work, but also the CEDAW committee in turn in making concluding observations to states parties, asked states parties to either invite you to their countries to on mission or cited your work. So, but as part of that continuum of international women's human rights work that you've led, you were appointed in 2015 by Secretary General Ban Ki-moon as the lead author of the study on UN Security Council Resolution 1325 to mark the 15th anniversary of this turning point in the Women, Peace and Security agenda. So that report is still one of the most important studies that came out of the United Nations, looking at what many have called the crowning achievement of the women's movement, the Security Council Resolution 1325, which saw women as not just victims of war, but active agents of peace. And so what I would like now for you to talk about is the importance of that resolution, what it signifies for women, not just during conflict, but before conflict and after conflict, and the ways in which that study still remains an authoritative study in this field.
Well, I think, the reason why this became a very important resolution is that the apex, sort of the body that has the power to punish and is extremely the important body of the United Nations is the Security Council. And for the most part, it has not been involved in women's issues at all until 2001. And in fact, it didn't like human rights issues at all. People do not realize that the Security Council never dealt with human rights issues until the Bosnian War and the Rwandan War. It took that for them to finally agree. So it was in that kind of momentum and that wave of the post-Bosnia and post-Rwanda that the Security Council adopted a resolution, 1325, on women, peace, and security. Basically, there were 4 pillars. Prevention of violations against women, protection of women from violations, the participation of women at the table, and the rehabilitation and recovery of women in the post-conflict situation. So it was a full agenda. But over time, they began to focus on sexual violence and violations. Over time, a monitoring and reporting mechanism was set up that would report to the Secretary General and the Security Council. And also, what was happening is that the Security Council would list parties, or the SRSG who serves the Security Council would make a report listing parties that commit violence against women in conflict, and they could, of course, then receive sanctions. So I think 1325 then set in motion that the Security Council would set up a framework, architectural framework, to deal with especially issues of sexual violence. Now, there's a huge debate going on whether we want to bring more and more issues to the Security Council, because that's when you get the publicity, that's when it hits the news, that's when it gets everybody, even within the UN system, begins to respond. But I also think that this rights framework, as opposed to a security framework, how do we blend those two? There's the right, because as we have said before, and we say in the global study, security in a country requires the rights of women be, if women are subject to greater violence, that's an indicator that the society is unstable. if women have child marriage or any kind of violations against women, usually that country is a little more unstable. So to make that link between, to not only focus on sexual violence, but to make that link with the more structural and deep root causes elements, and the fact that they result in a destabilized country and are indicators of trouble in that country, is, I think, something that is now being done by the civil society groups and the UN agencies dealing in this field.
So that has been an ongoing conversation that Radhika and I have been having in our class on women, peace and security here at the University of Pennsylvania Law School, where we look at gender discrimination and violence against women before war, pre-war, as important early warning signals of instability, impending conflict, and that women's human rights and threats to women's human rights, whether it is a spike in trafficking of women, violence against women, capture of women, sexual abuse of women, a spike in child marriage, are often harbingers of impending crisis. And that we ignore those indicators to our peril because of the traditional notions of security being very much framed within a narrow securitization and militarization framework. So it is important that we look at rights violations of women as important indicators and early warning signs of conflict. And I think the Women, Peace and Security Agenda, too, has seen this. And, I often call the Security Council 1325 and its progeny, because it has 8 Security Council resolutions that flesh out this framework. And the last one, which was introduced in April of this year, called for participation of men and boys.
Delivery service.
The delivery services of men and boys, but also the participation.
I don't think.
The participation of men and boys is implied when it calls for the delivery of services for men and boys, because you cannot deliver services without this being seen as not just a women's issue, but it is seen as an issue that engages men. So I'd like to read it in that expansive way. So and you talked about the 4 pillars: participation, prevention, protection, and peace building. So prevention is one of the central pillars, but we often ignore that, because we are still set on that narrow framework of conflict and war. But it is prevention of war, and peace building that is a centerpiece of the Women, Peace and Security Agenda. So can you speak to that through some of the work that you have done in this area?
Well, I think prevention is very interesting. You can have a hard-nosed approach to prevention, which is put forward by the doctrine that's called the responsibility to protect, which was brought because there was after the end of the Rwandan war, the peacekeeper in charge of the genocide of the UN forces during the genocide was so distraught after the fact that the UN did nothing and let this genocide take place, even though it had all the intelligence as to where the arms, etc., were being held, that he personally pushed the international system and his own government, Canada, to set up frameworks to deal with this horrific kind of violence. And so the responsibility to protect is a preventive measure. It says that if the envoy in New York begins to see all these indicators that things are not right, amount of people arrested, with female heads of households going up, these are the kind of indicators he looks at. Sexual violence increasing, violence generally increasing, that it is the duty of the government is reminded of its duty to protect its own citizens. Very few governments understand that there is a duty under international law to protect its own citizens. If that fails, Then you go into what is called protection, preventive diplomacy. To say, look, this is going to blow up, you have to do something. And then if all that fails and it blows up, then there's what they call the Chapter 7, where the countries can come, the Security Council can send a force to the country to protect the civilians. So that's the hard protection. But the protection that the humanitarian aid workers, the UN agencies believe in, is another kind of protection. That is like, first, the presence. Just the mere presence, first, of armed peacekeepers, or even non-violent peacekeepers from around the world. There was something called the Non-Violent Peace Group that still functions. They come and live in the village with the people, so that you can't attack houses, you'll be attacking them. And there's some kind of deterrence, and they're also witnesses as to what's going on. Then there's technology. You give each community a satellite phone so that they can call peacekeepers or somebody who has access in areas where there is peacekeepers living, or they can get to the police without having to run to the police station. The community mediation. Women do this. There's something called situation rooms in Africa, in countries with conflict, where the women gather, and if they see something happening, they go to the area and they begin to have discussions with the leaders who are beginning to start a fight. So all these kinds of preventive actions have been thought of now as ways to look at it. But the long-term prevention, of course, is to deal with the root causes, which is to do mainly with structural discrimination, issues of long-term poverty. So while at the same time you deal with the emergency of this breakout of violence, the development agencies of the UN and other parts of the world have to deal with the root causes and what happens with those root causes.
And those root causes are key because we are thinking of sustaining the peace. We are not thinking of a patchwork response. But what the Security Council resolution has resulted in through research done in this area is to show that the peace lasts longer when women participate in peace building, that there is that the peace lasts for more than 2 years and then increasingly for up to 15 years, depending on the number of women who participate in leadership in peace building. So that then takes me to the second pillar of your work on the global stage, Radhika, as Under Secretary General for Children in Armed Conflict, where you were the SRSG, the special representative of the Secretary General on children in armed conflict. So one of the important moments in your mission was when you addressed the trial in the Lubanga case, and you were at the ICC, the International Criminal Court. So can you speak a little bit about that mandate and your work in the Lubanga case?
Well, this was the first case before the International Criminal Court. And the prosecutor decided to make it a case on child soldiers because he felt that there would be a global consensus on something like that. But there was an uproar because there was so much evidence of sexual violence, but he decided not to put down charges. And in fact, the judges, in their judgment, reprimanded him, saying that there is evidence in the testimony of sexual violence, and why did you indict people for that? But we wrote an amicus curiae because there's an issue where whether what is deemed child soldiers are those that do the fighting with the guns. But in many of these wars, such as in Lubanga, there are a lot of people in the camps, especially women, who are running around cleaning and whatever, cooking and keeping the campfires burning. Now, what happens is there was a tension. On the one hand, the humanitarians wanted these people to be regarded as child soldiers so that they would benefit from the demobilization package. They would get money, they would be taken back to their homes, they would be given livelihood training, because it would only apply to combatants. So if they were not combatants, they get nothing. But the ICRC said, my goodness, if they're called combatants, then of course, according to international humanitarian law, you can shoot them, you can be targets. So this was the debate, and so we were proposing the humanitarian application, and the court then ruled with us, but limited it to say that it would be particular to link to the DDR-like process, so that to take away from states killing children, saying this is. They are also soldiers. So we put that amicus curiae down. So I was asked to go and give testimony at the ICC. Now, the ICC is an interesting place. For those of us brought up in the criminal law, it's a bit of a shock, because there's the judge, and then there's the prosecutor, then there's the defense, and then there's a third table, and it's the victims' lawyers. So the victims in this criminal trial, the victims have their own lawyers, so it's really 2 to 1. It's a very victim-centered place. So, part of me was fighting for the civil rights movement in the United States and for the rights of defenders. That's how I went to law school. So then to see a victim's rights defender against it, I felt strange, that it was a little unfair. But I gave my evidence. I was questioned by the prosecutor, Fatou from Basunda from Gambia. She made me lay out my 2 visits, who I met, what happened, as usual. Then I was waiting to be destroyed by the defense attorney, because, I went to 2 weeks, trips over 4 years period, about 3 trips, so altogether about a month. So, he could just have torn apart my, how many did you see, and what, just go into my facts and say, can you make a conclusion based on that? So I was expecting this line of very severe questioning, and I had prepared my answers. Instead, it was a French lawyer who then asked me all these philosophical questions, such as, don't you think in times of trouble, children should also join their parents in fighting for their community? Shouldn't the community fight all together? So these were the kind of questions that were being asked to me, and which, of course, I had answers for, because I've been lecturing on these issues. So that he really let me off the hook. It would have been harder to say, based on, say, a month of several visits, you can come to all these big conclusions. That would have been the line that would have given me trouble. But so that was interesting. And the Lubanga was seated in the last row. Now, this is interesting, of the courtroom instead of the first row. This all dates from the Akayesu trial, where the judge in this first case of sexual violence, when she gave her testimony, and then when I went to meet her after, she was shivering, because she was saying that the defendant was making all these sign languages with his hands, which were terribly threatening, and nobody else in the courtroom knew what it meant. So to prevent that kind of intimidation of witnesses, now the accused sits near the last row of the courtroom.
So we had as one of our guests Justice Navi Pillay, who decided the Akayesu case, which was the first case which defined sexual abuse in conflict as a crime against humanity and as a war crime. So these are all interesting stories that we hope you will share with us tonight when you share with us Diaries from the Field. But my last question to you is about your current position as a member of the high-level UN fact-finding mission on Myanmar on the Rohingya crisis, which is one of the greatest humanitarian crises of our time, and is part of the large, what I would say, migration crises that has engulfed our world. So can you speak to your work as a member of this fact-finding team, where you were denied entrance to Myanmar, but through satellite imagery, by speaking to these members of the Rohingya group, you have developed an authoritative study of over, I think, 400 pages, which I've had the pleasure of reading some, because we've been preparing our students on a student-led fact-finding mission to the Gambia, and I used your report as the blueprint, as the standard-setting report. So can you speak to that?
Well, we were the fact-finding mission on Myanmar was set up right after the Rohingyas were expelled. Now, 750,000 of them were expelled, and there was already 250,000 in Bangladesh. So with them arriving on this small piece of land that's called Cox's Bazar were 1 million people. So we went within 3 weeks of what took place. So there was no time to construct stories or make up stories or whatever. We went raw. People were really raw in their suffering. I was in charge of the sexual violence, and the women they just showed me the bite marks, the burn marks, the scars all over their bodies, as they had really, it was an attempt to drive them out of Myanmar. It was really an ethnic cleansing. We have said that you can investigate it for genocide. So it was absolutely horrific. But then Myanmar wouldn't let us in, so we couldn't interview the government, as to what their opportunity. I suppose one should give them the opportunity to be heard, though the ambassador did take us out to lunch and did speak. But what we did was, first we interviewed over 1,200 victims and witnesses. And this was done because, unlike other things, we had a team on the ground living in Cox's Bazar and taking down these stories. We had all the satellite imagery from the United Nations, which also buys from other satellite. You just see the people coming and the buildings you don't see the actual rapes and all taking place, but you just see, fully standing villages being just leveled, trees, everything. And then we had video clippage. Then we had with us, because the main damage was done by the Tatmadaw, the Burmese army, not the civilian government. She was not in the know, Aung San Suu Kyi, though later on she justified it. And the military, so we had a military expert with us, who was also helped us understand how the military is structured and why certain things can be considered war crimes and crimes against humanity, and how the training of this particular military, he looked through all their manuals. They were set up by the Japanese military in World War II. So their manuals and all are completely different to what we have here. So it's next to Rwanda, I think, the worst thing I've ever seen. So my worry, though, is the young men there. They do nothing. There's nothing for them to do. They only give education up to, even at that, to about primary school, but it's very barely anything. So secondary school, young people hemmed in this space. Only thing they do is they go to the mosque 3 times a day and they meet. And since my staff said, you interview violence against women, nobody is talking to the youth, young men. So I asked the young men to come, my last visit. And the bitterness, anger in these young men and the real horrific feelings that they were having, I felt they would just, anybody who wants to use them for something terrible, it would be just very easy. I mean, and I think people just don't understand that, and I think the Bangladeshis are beginning to understand it and feel, but there's no way of going back home because all the villages they lived in have been bulldozed completely, and they have set up. Other people have come and settled in those areas. They have now decided to try, and Bangladesh has put so much pressure to build some new villages. So they have set up some new villages, but they're not at all, no really sanitation. Everything looks completely strange. So the UN agencies and all do not want them to go back. And there's also a whole structure of discrimination against the Rohingyas, which people rarely talk about, but which is also there. They can't barely their education or health facilities because they're not considered citizens. So they're denied everything. There are laws about who they can marry. If they can't, they have to get permission to marry a non-Muslim. The number and spacing of their children is regulated. So what are they going to? They're going to take them back to that world as well. So it's a big crisis the world is facing, and these boys might get radicalized they're going to get radicalized very fast.
So Radhika, it is a time of reckoning globally, nationally, and here institutionally. And as part of that introspection, we constantly look at and examine our own role as a leading premier law school in the world. What is our moral authority in the world in shaping and informing justice, the rule of law, and good governance? And so your work at the highest level of moral authority, whereas the Undersecretary General working on issues that are some of the tipping points, right? Tipping points. As you said, the radicalization of these youth are going to change the world, as we know. And that is why your work as the special rapporteur, the special representative on children in armed conflict is really part of that central, I think, tipping point of the world. And so your work in the world and now the ways in which you're bringing that work here to Penn Law really strengthens Penn Law's moral authority in the world, because by training the next generation of those advocates and scholars, you are strengthening and elevating our role as a law school that is bent on shaping a new world order through our moral authority. So thank you.
Thank you.